case of Paula Foster and Edward Foster against State Farm Mutual Insurance Company.
May I please the court? I'd like to reserve 3 minutes for my name is Rebecca Creed. I'm with the Jacksonville firm of Creed and Gowdy, and together with Charles Sorensen, we represent the plaintiffs Paula and Edward Foster. The plaintiffs asked this court to reverse the trial court's final judgment on a jury verdict for 2 reasons. First, the trial court erred in refusing to direct a verdict as to permanency for the plaintiff. Second, the trial court abused its discretion when it denied the motion for new trial based on evidence on the defendant's failure to present evidence to refute the plaintiff's undisputed evidence as to permanency. The jury's verdict, its finding that there was no permanent injury, was contrary to the manifest weight of the evidence. For that reason, the plaintiffs are entitled to a new trial on permanency and damages. First, as to the directed verdict issue. The trial court erred in denying the plaintiff's motion for directed verdict. Although the question of permanency is usually one for the jury, where, as here, the evidence on permanency is undisputed, unimpeached, or not subject to question, and the jury is not free to simply ignore or arbitrarily reject that evidence, there must be some reasonable basis in the evidence for the jury to reject the expert opinions on permanency. Here, the plaintiff's experts all testified within a reasonable degree of medical probability that the plaintiff had suffered a permanent injury from the 2006 accident. The defense was then required, under the Florida Supreme Court's decision in Wall v. Granger, to either present countervailing expert testimony to severely impeach the plaintiff's experts, or to present other evidence that directly contradicted the plaintiff's opinions on permanency.
So could you just walk us through very briefly what the plaintiff's experts said relative to her permanent injuries? Because from what I can tell, they all pretty much acknowledged that she had at least some neck issues from a 1999 accident. So how did they get from that to permanent injuries from the current accident?
The plaintiff's experts, they did all testify that she had suffered a permanent injury. They recognized that she had pre-existing degenerative conditions, but that those conditions, at least as to her low back, had primarily been asymptomatic before the 2006 accident. They acknowledged that she had been in an accident in 1999. They knew that. The plaintiff had told them that. And they knew she had periodically treated with a chiropractor. But they looked to objective evidence of the MRIs and the studies after the 2006 accident, and also the plaintiff's reports of pain, her reports as to her pain levels before and after the 2006 accident, her work history and employment history, and they considered all of that evidence together, both objective and subjective, to find that she had sustained a permanent injury as a consequence of this 2006 accident.
So did the surgeries that were done on her neck, I guess there were discs that were removed and were replaced in 2008, 2009, somewhere around there?
Yes.
Those surgeries did not resolve her injuries?
No, there was testimony that initially they believed that the low disc surgeries had resolved her injuries, but then she reported in additional visits to her neurosurgeon that she continued to have pain and that those problems had not resolved. So that surgery that was as a consequence of the injuries sustained from the 2006 accident, her physicians all testified that trauma, like the 2006 accident, can aggravate, it can be a permanent aggravation of a pre-existing injury, and that's what in fact occurred here. The defense then had the burden to show, either with countervailing expert testimony or by presenting other evidence in direct contradiction, that this opinion evidence of the plaintiffs could be refuted. And the defense failed to meet that burden by showing countervailing expert testimony, first of all. The defense relied on one witness. The one witness was its medical expert, and he essentially refused to give any opinion one way or another as to permanency.
Let me ask you about that. What he said initially is a little conflicting, I suppose, in a sense. He says, I'm not sure if she did sustain a permanent injury or not from the 2006 accident. But then he went on to say, what I do feel confident in saying is that the majority of her symptoms in her surgery that was done was a result of other previous conditions. So he sort of said, I'm not going to opine about permanency. But then he comes back and really does sort of opine that I can't find any objective basis for permanency. And moreover, I do feel confident saying that her symptoms were a result of the previous situation. Why can't we credit that as being enough reasonable evidence in the record to support the drug issue?
Yes. First, because the evidence was what the defense should have refuted was the plaintiff's expert opinions on permanency. And here, the expert, he did, I take issue with the fact that he gave an opinion as to permanency because he really never did. He said, I can't say one way or the other whether she did or she did not sustain a permanent injury. He said, I find she lacks any objective abnormalities to support a permanent injury. But again, that's only one aspect of the opinions of the plaintiff's experts. He admits that her symptoms could have resulted, her current symptoms could be a result of the 2006 accident. He agrees, and a directed verdict was granted as to causation. He agrees that she was injured from the 2006 accident. He states that he believes the majority of her symptoms arise from pre-existing conditions, but he doesn't say all of her symptoms arise from a pre-existing condition. He was really unwilling or unable to give an opinion as to permanency within any reasonable degree of medical certainty. He didn't really add anything at all to the equation because he continually waffled and said, I'm not sure, I'm not certain. He refused to take that extra step, and even given all the findings that he had, he refused to say within a reasonable degree of medical certainty that there was no permanent injury sustained.
He did perform an examination.
He did perform an examination. Even then, he said, he testified as to all the documents that he had reviewed, her medical records, comparison of her MRIs, and even then, he still would not take that step to say, I find that there was no permanent injury.
He did sort of raise a question, though, when he was talking about his, physical test, objective test that he did on Ms. Foster.
Yes.
And his conclusions and the way he testified seemed to cast doubt on her subjective complaints of pain, which seemed to be really the only basis upon which her physicians have determined that she is suffering a permanent injury. Why is that not sufficient to have survived a motion for directed verdict?
Because he did testify that he believes she had not maybe made a full effort at her physical exam or may have given some inconsistent or incomplete testimony to her physicians. But once again, even notwithstanding his statements, he was not willing to say, I find within a reasonable degree of medical certainty that there was no permanent injury caused by this accident.
Why couldn't that have been a basis for the court not to credit the plaintiff's medical testimony?
Because there was certainly other evidence. The subjective evidence of pain was not the only basis for the opinions rendered by the plaintiff's experts. The plaintiff herself.
Did the plaintiff's expert attribute an anatomical change to the 2006 accident?
There was an anatomical change in the lower back that was attributed, and even the defense expert noted that was a new finding, but he claimed that was a pre-existing condition. But the plaintiff's experts did use that, and along with the subjective evidence.
So the court could have credited that defense testimony as to the anatomical change.
But even then,
and then all that's left to support the medical evidence produced by the plaintiff would be the subjective reports, and then those are called into question by the testimony that she was not being completely candid.
But the testimony that she was not being completely candid, this is not a case where that's in fact the case. This is not a case where she failed to disclose her injuries. All of her physicians knew about the 1999 accident. They all knew about the pre-existing conditions, and they all factored those pre-existing conditions into their opinion. The subjective reports of pain, the plaintiff didn't rely simply on her testimony. She also had other witnesses who testified as to her pain and activity levels before and after the accident. She had two of her employers who testified as to what a hardworking employee she had been in the years between 1999 and 2006. She had a very physical job at UPS. She'd been Employee of the Month in the month preceding the accident. And the physicians all looked not just to her subjective complaints of pain, but to her work history and all the evidence surrounding what she had been able to do before and then after the 2006 accident. The defense expert simply was unwilling or unable to say one way or the other whether she had sustained a physical injury as a result of the accident. And this waffling, I'm not sure, I'm not certain, it's just not enough to present countervailing evidence, expert opinion evidence under Wall versus Granger. The opinion in the Williamson case goes to that is relevant here because there, like here, it was just a question of maybe attacking a certain aspect of the plaintiff's opinion testimony, but certainly did not directly state that there was no permanent injury. Also, the other components relied upon by the trial court were some suggestion as to the earlier accident or the lack of force in the 2006 incident or the pre-existing conditions or the defense expert opinion testimony. And again, none of that directly and contradictly and clearly refutes the opinions of the plaintiff's experts that she has sustained a permanent injury. The objective evidence also goes to show that even though the defense expert may have testified to a lack of objective abnormalities, again, he conceded that many of her symptoms could be related, that he couldn't tell the jury one way or another whether she'd ever fully recovered. He conceded that trauma can cause permanent aggravation. He conceded that she could at least incur some future medical treatment and that she should be restricted from lifting more than 20 pounds. He admitted that there had been no restrictions placed on her before 2006. Again, the issues as to the supposed lack of informing her physicians about the prior accident or the pre-existing injuries are all essentially a red herring because she did inform her physicians as to those. There's no need for the plaintiff to introduce any evidence as to the comparison of the forces at fault in the accident because liability was admitted, and she was really the only witness who testified as to the 2006 accident. State Farm did not present any evidence to refute her version of the events for the 2006 accident. Let's see, and then to my rebuttal time to take what time I have left. Thank you.
Thank you.
May it please the court, my name is Rhonda Vargas, and I have the honor of representing State Farm Mutual, the appellant in this matter. As to the directive verdict issue, which is what counsel primarily argued over, it's very clear that those should be rarely granted and only when there's no reasonable inference from which a jury could find that there was no permanent injury. If the evidence is going to be viewed in favor of State Farm, and there has to be, and what the Supreme Court has said is that once they present evidence of permanency, there is a burden shift, but State Farm just had to produce evidence which would otherwise subject to question the evidence presented by the plaintiff. In fact, the Florida Supreme Court said some reasonable basis in the evidence, which can include conflicting medical evidence which calls into question the testimony, including conflicting lay testimony. So in this case, we have an individual who is in a degenerative disease in both her cervical and her lumbar. This is not just by Dr. Hoffman. Dr. Kilgore agreed that there was a pre-existing condition, and Dr. Canesta, actually Vicente, agreed that there also was a previous existing condition. Dr. Kilgore, in fact, even admitted that he believed that there was some causation relation between the 1999 accident and her injury. You have her chiropractor, Dr. Pierce, who says that when he released her at MMI, she had a permanent injury. There is some discrepancy between his direct and cross as to whether it was only to the neck, but his diagnosis at the time that she was put in MMI included lumbar back. So we have that information there. We have her doctors and her experts who found permanency basically saying the reason we believe that there was a permanent injury due to the 2006 accident is that her pain increased and her activities of daily living had changed. That brings it right back to the plaintiff. So I would submit, even without expert testimony, there is enough evidence in here that there is a reasonable basis or a reasonable inference for a jury to find that she was not permanently injured. Her injuries occurred as from a combination of degenerative disease process as well as the very severe 1999 accident. There was testimony she had told her doctor, another doctor, Dr. Harris, that she had suffered injuries to her neck and back. So there was quite a bit in there. And there's also not only, as Your Honor pointed out, Dr. Hoffman had, on one of her tests, she had pain where she shouldn't have had pain. And one of them, she had give-way weakness where there should not have been give-way weakness.
Well, counsel, let me ask that. I've got two questions about Dr. Hoffman. I'll do the second one first because it relates to what you're talking about right now.
Okay.
He did this Waddell test, I guess, where he gives tests to the person, physical test, to detect whether the pain that's radiating and so forth, the movement of the joint and so on, is present. So they'll move a joint, and if there's pain present, they'll note it. If there's not, they'll note it. And there's, according to this test, as I understand it, it's a way of determining whether there's a true injury there or not. And his testimony was essentially that he felt that she didn't pass that Waddell test. Right. So that's where this credibility issue arises about her testimony about her injuries. My concern, let's assume the Waddell testing is standard practice out there. I don't know if it is or not. My concern is if the plaintiff put on the case, a powerful, persuasive case of permanency from a number of experts, can a defense expert just come in and say, well, I'm moving some folks around and I don't think she's telling the truth?
Well, I do believe that if there is reasonable inferences in evidence, lay testimony, or doctor's testimony that calls into question a plaintiff's complaints of pain and the patient's reported ADL changes, that probably would meet the directive verdict because all you have to have is a reasonable inference. In this case, though, that's not what we have. He actually opined that there was that his diagnosis was pre-existing cervical condition.
Well, that's the other question. The two-part question. First one was the Waddell testing,
right,
which concerns me a bit because I don't know that much about it, just from what I've read in the record here. Then this other aspect where I think is more helpful to you, although this testimony, I don't understand why he didn't just say, I find the permanent injury, because he said there's no new objective findings after the 2006 accident compared to what was there before. So he is opining there's no medically objective basis for anything new.
Right.
And I don't understand why he then comes back and says,
I
can't tell.
And he also gave an opinion within a reasonable degree of medical certainty of what her diagnosis were, and he actually said lumbar strain, cervical thoracic strain, previous lumbar disc disease, previous degenerative disc and neck. I think it appears to be a hesitancy for him to say that what she was complaining about, that he came short of saying that she was lying. He said there could be some psychological overlay, that she was a poor historian. And again, as to her credibility, Dr. Canestra, who did the surgery, actually says, I do the surgery, it's a complete success. She returns to me 1 month prior. She's since then moved away. And she comes back to see these doctors to, quote, get ready for her litigation 1 month prior to trial. She goes to see Dr. Canestra and says, my pain has gotten worse. It's gotten a lot worse. And Dr. Canestra said, I don't see any objective evidence that her condition has changed in the last year. Again, contradictory to what the plaintiff has said. So we have a situation where there was certainly reasonable inferences. It's a very, very, very tough standard to get a directive verdict on permanency, and we're not even close.
You probably don't know the answer to this, but what more could this defense expert have said, except this is not a permanent injury? In other words, I still have trouble understanding why he backed off on permanency and wouldn't take a position, even though he seems to testify about it around the perimeter of the issue.
I don't know, and I think that was because the issue of permanency may be related to pain complaint, and he just was stopping short of saying, I'm not going to say she's not continuing. I don't know. Because I think it all around.
Ruling out any objective change in the sense of he's saying the only possibility is that there's something to this objective
subjective.
Subjective symptoms that she's reporting, but as you say, didn't want to say.
He didn't want to
She's
say
being
that,
untruthful.
and I don't think he had to. I don't think he had to. And in fact, the fact that, and he's not the only one, this is not a situation where he's saying, I think this all was degenerative and related to previous accident, and the other doctors are not saying that. The other doctors all said, yeah, we agree. And Dr. Kilgore even said, yes, it was related to the 1999 accident. The only reason Dr. Kilgore found that there was a permanency because of the 2006 was her self-reported pain and ADL.
Is the diagnosis of strain itself inherently temporary?
Yes. Yeah.
And that was his diagnosis?
That was his diagnosis. His diagnosis, within a reasonable degree of medical certainty, was lumbar strain, again, which goes away, cervicothoracic strain, then previous lumbar disc disease, previous degenerative disc in neck from before 2006 accident, and he was unequivocal that the surgery and all these pain injections and things that were going on were not caused by the 2006 accident. There are also issues as to what she told her physicians who did come to permanency grading determination. She generally told them she was in this minor accident in 99, suffered some whiplash, and it went away. It resolved. This is a lady that 1 month prior, their chiropractic visits had decreased, but 1 month prior to the accident, she presents with moderate bilateral neck pain. So the neck pain resolved. She testified, no, it wasn't really neck pain. I just needed an adjustment. I was stressed. I had this job. But that's for the jury to determine. There certainly was evidence that she was suffering from pain prior to this accident, such that she even didn't even describe it as minor. She described it as moderate. So again, that brings it back. I mean, a directed verdict is a very, very strong, very difficult hurdle to conquer. And in fact, there's even cases that without any countervailing expert testimony, you've got issues where, for example, one of her doctors said if he had known that she had a previous diagnosis of sciatica, which is basically pain, radiating, that would have been information he would have liked to have had. He was not provided that information. He didn't review the records. A lot of them, the records were provided and the information about permanency were provided around their deposition, but the bottom line is they were relying on the plaintiff to tell them when these neck and pain complaints came, and they did so. And so if the jury, who has the opportunity to view her, doesn't believe her, and there were other issues in relation perhaps to her job, why was she reducing her hours prior, what was her real intent.
All right, so they're also arguing that even if this is a question for the jury, we need to go back and give it to another jury.
A manifest way of the evidence. Again, on that standard, on the directed verdict, it is de novo. This court can look at the evidence and decide if there's a reasonable inference. On manifest way, you have to find that the trial court, who very unusually wrote a detailed order denying a motion for new trial. Typically, I see order motion for new trial denied. He wrote a very detailed order explaining and applying not only the correct standard, but there was no argument that he made any factual findings that aren't supported in the record, that anything he referenced in that order was incorrect. We're not dealing with that issue. We're dealing with a judge who looked at it, and he had the benefit of seeing the witnesses, of being in the courtroom and seeing, and he determined that it was not against the manifest way of the evidence, and that it wasn't a simple matter of how many experts did you have and how many experts did you have, that he found, based upon the testimony regarding the objective lack of change between the 2004 cervical and the 2006 cervical, that there had been no change before and after the accident, that she had a previous severe accident, that she had previous permanency and previous degenerative disc disease, and that there were some issues regarding whether she had radiating pain beforehand and whether she was an accurate historian, that it was not against the manifest way of the evidence. The court was in its discretion in ruling on that, and it certainly does not arise to a clear abuse of discretion. You have the benefit of his reasoning, and I would suggest that he absolutely went down the list of what the standards to be applied for, and the court went through it and appropriately determined.
Now, he didn't have the benefit of the Supreme Court's decision.
He did not, and that's an interesting issue because I raised that up. He actually recognized that there was a split at the time between the second and the fourth, the second and the fourth and the first. He went ahead and analyzed on the director's verdict. He went ahead and analyzed it also under the second and fourth position, and in fact, he expressly did so. That's on the bottom of page 3. He said, even if this court were not bound to follow the decisions of the first district, the evidence related to the prior accident, pre-existing condition, the lack of evidence related to the source of the impact, and the opinions of defense experts. And he went ahead and applied what would be the Walt standard. But I would actually submit that even if he had only applied any evidence is sufficient, because this is de novo review, your honors are basically in the same position in ruling on the directed verdict. And as long as you find that there is a reasonable inference of evidence which contradicts this permanency, that the directed verdict would have been improper. So therefore, the fact that Granger was not out at that time does not dictate a reversal. Unless there's any questions, I'll otherwise stand on the brief, and we request that the satisfaction of the jury verdict does not mean that there is any error, and that the judgment should be affirmed. Thank you.
Thank you.
May I please support? Here there was no reasonable inference that could contradict the plaintiff's undisputed opinion expert testimony. The defense expert refused to say one way or another. He couldn't even say with any certainty at all that she had not sustained a permanent injury. He certainly didn't testify within a reasonable degree of certainty.
What do you say to opposing counsel's contention that by saying that within reasonable medical probability the only exacerbation had been strains, that the clear import was that the exacerbation was temporary and not permanent?
I'm not sure where on the record that is, that the only exacerbation was strain. He did testify that the strains were caused by the 2006 accident, but his findings that he couldn't state with certainty were he believed a majority of her symptoms arose from pre-existing conditions, and that there weren't any objective abnormalities to support a finding of permanency. But that doesn't go to show that all of her symptoms now arose from the pre-existing condition. In other words, by stating that only a majority of her symptoms arose from pre-existing conditions, that necessarily leaves open the question as to, well, then aren't some of her conditions and symptoms related to this accident, aren't some of those permanent? And he could not say one way or another whether some of her symptoms weren't related to this accident. He admits that he can't say that. He's not here to tell the jury whether she doesn't still have symptoms from this accident. He does concede that she could have symptoms related to the 2006 accident.
Can I ask you quickly? Is it your contention that the plaintiff comes in and has 3 experts who testify about permanency of an arm injury, a leg injury, and neck injury, 3 separate areas, but the defense counsel has to come in and counter each of those directly?
Yes, it is.
Or would somehow put the entire analysis into question as to the 3 individual?
Yes, like in the Supreme Court's decision in Wall v. Granger, and there were several different injuries, but the one that was not refuted was the right thigh or the left thigh, or whichever one it was, and that was enough to direct a verdict as to that particular injury. And if there's any part of the bodily injury that is permanent that arises from the accident, then the jury is entitled to consider pain and suffering. So it's either that the defense expert needs to present evidence to contradict at least one of these opinions of permanency, but it's not just enough to attack certain aspects of the opinion. It's going to be the entirety of the opinion, either through directly contradictory lay witness testimony or expert testimony. So we would ask that the court reverse and re-examine with instructions to direct the verdict as to permanency and to grant a new trial as to damages. Thank you.
Thank you, Ms. Reed.